Member Klein, Chairman Miller, members of the subcommittee, for the opportunity to appear before you today to discuss the fair disclosure, fair 401k Fair Disclosure for Retirement Security Act of 2009. It's an honor and a privilege to appear before you today. I'm testifying today on behalf of Fund Democracy, an advocacy group for mutual fund shareholders that I formed about 9 years ago, but I would be remiss not to mention Barbara Roper, the Director of Investor Protection at the Consumer Federation of America, with whom I've developed the positions that you see in my written testimony over past testimony and comment letters. The 401k Fee Disclosure Act reforms are long overdue. Under current law, figuring out your 401k fees is like trying to find a needle in a haystack, except the needle has been broken into 3 parts and they've been put into 3 different haystacks. The investment management fees appear in prospectuses. The plan fees appear in something called a Form 5500, and any other account fees that are specific to the participant appear in yet another document, their quarterly statement. The prospectus fees are provided as a percentage of assets. The Form 5500 fees, if any participant could actually find those, are provided as a dollar amount and not even on a per account basis. So even if you were able to find all of these fees, you would still have to convert either the prospectus fees, of which there may be 15 or so different options, into dollars, or the 5500 fees into a percentage based on the entire size of the plan, and then figured out what it would be on a per participant basis. And then you would have to figure out what appears on your quarterly statement and figure out that as a percentage of fees. And then finally, you would have, for at least one period of time, some idea of what you're paying in 401k fees. If you have any doubt about the absurd patchwork of disclosure requirements under current law, I suggest you visit the Department of Labor's website and review their own brochure, A Look at 401k Fees. The section that explains how to find out what you are paying in fees would bring tears to the eyes of anyone who has any kind of commitment to fee transparency. The 401k Fee Disclosure Act solves this problem by requiring that all fees be disclosed in one place, in one format. The Act is a breath of fresh air in a regulatory environment that continues to be unfriendly to investors. The SEC recently announced the suspension of reform of 12b-1 fees and appears to be preparing to lower fiduciary standards for investment advisors. The Department of Labor has proposed rules that effectively protect conflicted investment advice provided to plan participants. The Act's requirement that fee disclosure also appear in participants' statements, which they are actually likely to review, is also a major step forward. It also requires that the fees be provided in dollars, in the same place that they will see the value of their accounts in dollars. For the first time in retail financial services history, the Act will require that fees be provided in a comparative format so that investors can place their fees in context. Standing alone, fees mean nothing to the fee-insensitive investor. Also, for the first time, the Act recognizes the importance of giving participants freedom of choice in deciding whether to invest in a passively managed fund or an actively managed fund that also will inevitably impose higher fees. Actively managed options as a group will by definition necessarily underperform the market by the amount of their fees. This means that in the aggregate, active management fees are a dead weight dragging down overall investment returns for 401k plans. Participants who are required to invest in actively managed funds may significantly outperform the market, but they may also significantly underperform the market, as many have. It is unclear how employers can, consistent with their fiduciary duty, force their employees to pay higher fees and assume active management risk. The answer may be that financial services industry has every incentive to steer participants into actively managed funds, which are more profitable than passively managed funds. This is the only way to explain the industry's Orwellian position that offering a passively managed investment option somehow limits choice. The industry argues that we should be focused on the employer's freedom of choice, not the employee's. But it is the employee's choice and financial security that should be our focus. The financial services industry would leave the decision to the employer and have us ignore the warning issued by the intellectual father of capitalism, Adam Smith, that, quote, managers of other people's money rarely watch over it with the same anxious vigilance with which they watch over their own. They very easily give themselves a dispensation. Jack Bogle reminded me of that piece of wisdom in the opinion section of yesterday's Wall Street Journal. The employer stock option in 401k plans is another example of the incentives of managers of other people's money. Employers have every incentive to create and encourage a captive class of shareholders, as illustrated by the image of Enron executives exhorting their employees to buy more Enron stock. We offer tax deferral to workers in order to help them prepare for retirement, yet we then permit the workers to use that tax benefit to gamble 100% of their retirement security, not just on the stock of a single company, but on the stock of the company on which they also depend for their income. I strongly encourage Congress to consider limiting employees' investment employer stock to 20% of their account balances. But even without such a provision, the 401k Fee Disclosure Act promises to enhance transparency and promote competition in a way that I'm confident will lead to lower fees for America's tens of millions of 401k participants. I'm pleased to express my support for the Act and would be happy to answer questions that you might have.